You have the floor, madam.
Thank you, Mr. Chairman. Distinguished participants, first of all, I have to admit that I have a very difficult task to finish my presentation in 12 minutes and to overcome a delicious lunch and the sleepy feeling of all the participants in early afternoon. And my topic is focused on the arbitration award and the impact that the award may produce for the claimant state. I will try to limit myself within 12 minutes, 3 main points. First, I will cover some main achievement from the award. Second, I will analyze some argument on legal significance of an award from arbitration in general to third party. And finally, I will highlight some implications that I think is possible to produce for the other claimant state in the South China Sea. So let's begin with what happened with the achievement from the award. So I would like to draw your attention from in two maps on the screen. The map on your in this side is the before map of the award, and the map here is the after map. So the most significant differences is a lot of line has been removed from the after map. And the first kind of line has been removed is a 9-dash line. The second kind of line has been removed is all the green circle that indicate the possible 200 nautical miles from EEZ and continental shelf of the high tide features in the Spratly. So now we have quite benign pictures of the South China Sea after the award, where we only have all the line indicate the EEZ and continental shelf from the mainland of the littoral states and possible 12 nautical miles enclave for the high tide features of the Spratly and the paracel and the Spratly. So that is the biggest achievement. And in order to overcome all the legal arguments, the tribunal also make a conclusion in some kind of activities that I kind of summarize and categorize them into 5 types of activities. The first type of activity that the award handle is activities that have been conducted within the EEZ and continental shelf of the Philippines, like for example, deploying of the marine surveillance vessels, the fishery activities, and conduct artificial building islands within the EEZ and the continental shelf. It has been concluded it is a breach from the UNCLOS on the right and obligations of the coastal state. The second kind of breach is the breach of traditional fishing right that have been concluded exists within 12 nautical miles of Scarborough of the Filipinos and also for China's fishermen. The third one is the breach of obligation to protect the marine environment by conducting some practice of exploiting the endangered species and conduct some land reclamation that cause a harmful effect for the environment. The fourth breach is the breach of obligation to ensure safety at seas by conducting some activities that increase the risk of collision at sea. It is a breach of the Convention on Maintaining Safety at Sea. And lastly, during the proceeding of the arbitration, certain conduct has been happened to exaggerate and extended the scope of the dispute. That's why it has been concluded that also violate the general obligation of self-restraint and peaceful settlement of the dispute. So basically, what we can take away from the award is the award illustrates the triumph of international law. The award has contributed significantly on the provide a clarification and significantly narrow the scope of the dispute among the parties, and also the first success in using third-party dispute settlement in the way of arbitration illustrate that actually the party have more alternative to settle dispute than just negotiation. Now I would like to briefly overcome how an arbitration award in general can produce an impact for a third party. Normally, the term party and third party indicate that party mean the two sides in a case, and third party mean any party that fall outside the two parties of the case. So here we have the arbitral award between China and the Philippines. So therefore, the first principle in international law is that the case only final and binding upon the party concerned. That means China and the Philippines. But the case actually in state practice produce credible, significant role in providing guidelines for other states. They normally quote the judgment and award from the other courts in their legal argument in the future. The court and arbitration themselves also can use the award as a credible source because they often cite the previous cases in their future judgment. And also, there is a high possibility that the legal reasoning within an award in the future can be crystallized in customary law, international law, and also codified into treaty law. So with great significant role, it's up to the party whether the party recognize or will consistently cite and repeat all the legal reasoning in the future that will give the rise for the role of an award. And then finally, I will come to the main point on what kind of implication that the award can produce for claimants. So in word, I highlight kind of 8 potential implications that it may produce for parties, not just China and the Philippines, but other claimants in the South China Sea disputes. First one, as you can see in the map, now all these areas it become EEZ and continental shelf for little states. So according to UNCLOS, the leader states have right to conduct fishing, hydrocarbon resources exploitation. So any kind of fishing activity that conduct within the EEZ of the little state, it will be illegal fishing. And by that, the quota state has rightful right to exploit their jurisdiction, law enforcement forces. And even though the quota state can coordinate with each other in the overlapping EEZ to conduct joint patrol to maintain the legal fishing and responsible fishing practice. The second implication that we can see from the award for the other party is that although in the award the court only conclude on the right of joint traditional fishings for China and Philippines within 12 nautical miles of Scarborough, but in an analysis, it can apply for the 12 nautical miles of Stradley and the paracels. So therefore, it can stand for an example of fishing cooperation in 12 nautical miles of the paracel and the Stradley in the future. The third point that produced implication for the party is that because of no overlapping maritime zone exists in the center of the South China Sea, so all this area now become high sea and the international seabed of the South China Sea. And given the existence of the current legal regime provided for under UNCLOS, the other party, not just the claimant state, will enjoy the freedom of navigation, freedom of overflight, and freedom of the high sea, even exploit the resources in the center of the sea, the high sea, and also follow the management of International Seabed Authority in the international seabed in the middle of the sea. The next obligation or implication that can draw out from the arbitration award is that regardless maritime zones, it doesn't matter which maritime zone it is, every country has the obligation to protect marine environment and maintain the safety at sea. It is also an area that produces right and obligation for other states, not just claimant state. And it's also an area that can provide for further cooperation in the future. Yet, the arbitration award hasn't touched upon the sovereignty issue. If you look at this map, so what has been clarified by the award is just a maritime issue, but who owns the features hasn't been talked in the award at all. Why? Because it is an arbitration established under UNCLOS and have no jurisdiction whatsoever on sovereignty issue. Therefore, the country in the future still need to maintain negotiation in good faith to talk about sovereignty matter. However, the award has provided clarity for the scope of sovereignty claims. For example, if you look at the status of low tide elevation and the ruling of the arbitration on the impossible to use straight baseline or archipelagic baseline to claim the whole Stradley, then it is a kind of limited the scope of the sovereignty claim. How can it make? If you look at the map here, you can see the two lines, the red line and the yellow line circles the paracels. It is the archipelagic baseline that China draw for the paracels. And according to the court, the arbitration, it is not possible because archipelagic baseline can only apply for archipelagic state. China cannot be an archipelagic state, so cannot use that baseline. And also the only claimant state is the Philippines, which can use that method, but it will exceed the condition of water to land ratio to apply the measures. So what is possible for the party? The party should identify which feature is high tide feature, which feature is low tide features, and only can claim the low tide features if it's located within 12 nautical miles of any high tide features. So in the two maps, I try to illustrate the possible future that a group of features can be grouped with each other. So all the triangle in pink is a low tide elevation, but because it's located within 12 nautical miles of the red, which is a high tide features, so it can group with each other. But totally, every feature cannot group, as in the case of the paracels. So by that conclusion, the scope of the sovereignty claim will be much reduced, and it's up to the state to clarify in the futures, because in the award, the court just provide the clarification for certain feature according to the submission of the Philippines. Next, it is the COC. I heard a question in the panel before about the COC. Actually, from point 5 to point 1 to point 5, it can provide a symbol for COC or an element for the COC. Given the scope is clarified, given the behavior of the party is clarified in the award, so it can be provided a good guidance for the COC negotiation in the future. Given the number 1 to number 6, it can be presented as a potential cooperation in the principle of solving the dispute and non-prejudice. That means whatever you cooperate with each other will not affect the prejudice of your claim in the futures. And also, as I mentioned before, the success of the case highlight that it's possible for the party to pursue third-party adjudication to settle the problems. Of course, certain part of the dispute still can have only means to solve through negotiation, but with relevant party concern. But third party now really become a possible, not something that impossible that we considered before. And with that, I would like to conclude my presentation here. Thank you for your attention.
Well, thank you very much for this excellent overview of the main findings of the Arbiter Award, and also thank you so much for exactly sticking to the allotted time. Let me just make two comments. You rightly highlighted that the arbitral award is binding only upon the parties, but there may be effects beyond, and that such a decision is often cited by other international courts and tribunals which may refer to it. But the question is, will other courts or tribunals who may be dealing with similar issues stick to some of the findings, or may they arrive at different conclusions? So this remains to be seen in the future. And you also mentioned state practice, and you said state recognition and practice will decide. That is very true. So we'll see in which manner state practice will go. So it's hard to say at the present time. So the next speaker on the list is Professor Yan Hui Song, Institute of European and American Studies, Academia Sinica from Taiwan. And the title of his presentation is The Arbitration Award and Implications for the Activities of Parties in the South China Sea. You have the floor, Professor.
Thank you very much. Thank you very much, Chairman Tuerk. Good afternoon, distinguished speakers and participants, ladies and gentlemen. I would like to begin by thanking the President of Diplomatic Academy of Vietnam for inviting me to this conference. I was asked to speak on the Arbitral Award and its implications for the activities to be conducted by the parties in the South China Sea. My paper and my PowerPoint files are available to all of you. I look forward to your comments and suggestions to help revise my paper. But due to time limitation, I would like to present my concluding remarks first. And after that, I will mention a number of needs that, in my opinion, should be considered by the parties concerned for the purpose of helping maintain peace and stability in the South China Sea. If I have time, I will mention a number of important implications of the war for the activities conducted in the South China Sea. So please move down to the end of my PowerPoint. I don't have the, to the end, last two. The tribunal's finding, keep going please. Yes, the tribunal's findings and declaration in the award will have important implications for a host of activities to be conducted by the two parties to the arbitration case, by other claimants to the South China Sea maritime disputes, and by external parties or user states of the South China Sea, such as the United States and Japan, particularly in the overlapping and or contested waters that are enclosed within the Chinese night-dash line. So these activities include fishing, oil exploration and exploitation, marine scientific research, navigation and overflight, plus construction and land reclamation, law enforcement, and patrolling at sea, and so on. Next, please. So legally speaking, or politically speaking, it is indeed possible for the parties concerned to make adjustments to their maritime claims and positions on the South China Sea issue in accordance with the tribunal's ruling. The tribunal's ruling is important as it is possibly to be cited by the parties concerned to help determine the nature and the scope of permissible activities in the South China Sea under the UNCLOS. So one of the biggest challenges in the management of the potential conflict in the South China Sea is the intention of the Philippines, other claimants to the South China Sea disputes, or external parties to conduct activities in the waters enclosed within the night-dash line, or in the areas near the man-made islands built by China for the purpose of either testing Beijing's willingness to comply with the decision made by the tribunal or forcing China to accept the outcome of the South China Sea arbitration. And now let me move to a number of needs, which in my view, and it's not in my PowerPoint, I said it's extra. In order to have dispute-free activities to be conducted by the parties, there is a need to reconsider their respective maritime claims and positions by taking the outcomes of the arbitration case and the relevant provision of the UNCLOS into consideration. It is necessary, there's a need to reconsider the issues of jurisdiction in the South China Sea after a award being issued by the tribunal, which can be grouped into three categories. First, activities to be conducted in the areas that are subject to national jurisdiction. Second, activities to be conducted in the areas beyond national jurisdiction. And third, activities to be conducted in the areas where national jurisdiction is overlapped or disputed. There are more needs. There's need to reconsider the concept of common heritage of mankind and its application to the South China Sea. there's a need to reconsider the importance of resource sharing, both living and non-living, in the South China Sea. There's a need to refocus on the common goal of win-win solution in the South China Sea, in particular, to transform the sea of confrontation into a sea of peace, friendship, and cooperation. More needs. There's a need to reconsider the right to participation of all parties concerned, including the United States, Japan, India, the European member states, in the future management and cooperation process in the South China Sea. So there's a need for the external parties to reconsider their policy options with regard to sending more businessmen, money, investment to the South China Sea, instead of sending warships, bombers, or surveillance vessels. Now, as reported, President Obama and Secretary Kerry decided not to lobby the US Congress for supporting the TPP proposal. So it's likely that the TPP will be dropped by the new Trump administration. Accordingly, there is a need, in my opinion, for the countries that border the South China Sea to re-examine their positions and the policies on issues that are related to the development of ASEAN economic integration, AIIB, One Belt, One Road, RCEP, free trade agreements, blue economy, and other economic-related matters. There's also a need to re-emphasize the duty to protect the marine environment and marine biodiversity in the South China Sea. In particular, a need to establish a regional fisheries management organization in the South China Sea to combat IUU fishing. There's a need to re-emphasize the importance of and duty to cooperation in the South China Sea in accordance with Part 9 of the UNCLOS, in particular Article 123, because South China Sea is a semi-enclosed sea. And this importance has become accepted, especially after the ruling. So there's a need, finally, the need to include the 2002 DOC in the South China Sea. The ongoing consultation on the adoption of the COC in the South China Sea, and Part 5, 6, 7, 8, 9 of the UNCLOS into policy consideration when the South China Sea issue are handled. So I have 3 minutes, and most of my points with regard to implications are in my slides and in my paper. But I have 3 minutes, so let me try to mention that the important reactions to the tribunal's ruling by the parties, by the organization, ICJ, UN, United Nations, European Union, ASEAN, will have important impact on the future implementations of this arbitration award. The United States say that this award is binding. And the United States urged China to comply with the ruling. But we are seeing, I don't know if you agree with me, I'm seeing the changing attitude of the United States under the Obama administration. In September at the United Nations General Assembly meeting, he did not address the arbitration award at all. And now the new government, what about the new Trump administration, after January 20th, Greg Poland, director of the Asian Maritime Transparency Initiative, everything possible. Are we going to see that kind of changing attitude of the United States? In particular, action taken by the United States to force China to comply with the ruling. So there are a number of factors in my paper. For example, sovereignty disputes continue, remains, right? And the 9-dash lines is not illegal. And there's a need to examine the maritime zonal and entitlement claims. Claims to the low tide elevation sovereignty, high tide futures, sovereign rights and jurisdiction are affected by this ruling. And there are also other needs, and I don't think I have to go over. But the important thing is that the parties in the arbitration case and other claimants to the South China Sea disputes, user states or external parties, they will have more policy consideration to follow, mainly because activity for them to conduct in the future will be affected by this outcome of the South China Sea arbitration case. I see my time is up, so I look forward to your comments and suggestions. Thank you very much. Thank you.
Thank you very much, Professor Song, for your enlightening presentation, which really complements the presentations we have heard before. Just let me raise myself 2 or 3 points. You highlighted that there are important implications stemming from this arbitration for a host of activities, and then we also distinguished between activities to be conducted in areas of national jurisdiction, in areas beyond national jurisdiction, and in disputed areas. So that's a very clear distinction between the different areas of application. And you also highlighted that the South China Sea is a semi-enclosed sea, and under the Law of the Sea Convention there's a duty among the coastal states in this area to cooperate. That's highly important for any further prospects of a resolution or management of the conflict relating to the South China Sea. But you also made a prediction, and you said it is likely that the parties will make adjustment to their claims in light of the award. And as far as that prediction is concerned, perhaps we'll see whether it will come true at the 9th South China Sea International Conference, perhaps to be held next year. And just one last comment. You also mentioned the United States. But of course, it is not so easy for a non-party to an international convention to ask a state party to such a convention to comply with its provisions. And I think the prospects of the US adhering to the Law of the Sea Convention have become more remote than they were just a few days ago. So I may now give the floor to the next speaker, Professor Stein Tønnesen, Research Professor, Peace Research Institute, Oslo. His topic is, will the arbitration award improve or impair the prospects for conflict resolution? You have the floor, Professor.
Professor Helmut Tuerk, I'm grateful to the Diplomatic Academy of Vietnam and to the Vietnam Lawyers Association for allowing me to serve on your panel. As a peace researcher, I am fascinated by the United Nations Convention on the Law of the Sea, although I have never studied law academically. And this is because of the basic difference between how territorial disputes are resolved on land and at sea. Because on land, it's basically based historically on power control, and the borders are drawn. But in the sea, it's based on geography. So in principle, it doesn't matter who has the largest navy in the South China Sea when you do maritime delimitation. It matters only for land and islands. On this basis, I have, over some years now, together with Professor Song Yan-wei and also Professor Zhou Keyuan, tried to look into the impact of the Law of the Sea Convention on state practice, and mainly on the question of conflict or peace. And we have found in an article that Song Yan-wei and I published together in Ocean Development and International Law that this is ambiguous. Sometimes developments in international law have exacerbated or created conflict, and sometimes it helps manage or resolve them. And now my concern is about this Arbitral Tribunal's award. How will this work? Will it mainly generate more conflict, or will it mainly provide possibilities for peace? And I must say that my answer is relatively pessimistic. But I have 6 points, and it's the 5th and the 6th point that are the most important for me. So I will go quickly through the first one. The first, this is a little bit speculative. I'm asking, how could it impact conflict and peace? And the first question is, does it at all have any impact on the question of sovereignty to islands? And the answer there is clearly no. The Arbitration Tribunal has not said anything about that, and it doesn't affect that at all, regardless of who has the economic zone around the islands. It's other matters that will decide the question of the dispute over the sovereignty. The second question I have is, what does it mean that the Arbitral Tribunal has declared activities undertaken by China as being illegal under international law? And this goes primarily for the construction of artificial islands and law enforcement against fisheries, traditional fisheries by other countries. And my fear was that to declare this illegal, and given the fact that it's unlikely that China, after having built all these artificial islands, will abandon them again, then it might lead someone to try to force China to abandon them, which would lead then to more conflict. But I suppose this will not be happening, because the illegality of it will not be followed up through any kind of enforcement by anyone, and therefore these illegal artificial islands will simply remain there as a nuisance, but not creating armed conflict and also not contributing to peace. The next impact that I'm looking at is this ruling about the U-shaped line and about historic rights. Because on that point, I regard the ruling as pretty definite, and that the question of having historic rights within the whole U-shaped line has been resolved, and sooner or later must be accepted by China and Taiwan. This is so obvious in international law, and the argument is so strong in the award. So there is really no possibility to step back on that. I think sooner or later China and Taiwan must decide that the U-shaped line means a claim to the islands inside it and their maritime zones, and walk away from the imprecise language they have used so far about relevant waters or adjacent waters or surrounding waters. But the problem is that when you go as far as the Arbitral Tribunal does in also invalidating Taiping Island or Ituaba's right to more than 12 nautical miles sea, and using arguments that would seem to set a precedent also for Woody Island in the Paracels, then China ends up with so little in the South China Sea, so this becomes unpalatable for one of the world's two main powers. So this means that the neatness of the solution, where you actually much facilitate maritime delimitation, becomes impracticable, practicable, and unrealistic. So in a way, my immediate positive reaction to seeing this neat solution is very much mitigated by my pessimism as to the possibility of China ever accepting this. The next question I had then was, is it possible that on this basis of the award, China and Taiwan could simply be neglected or ignored, and the rest of the countries could now start delimiting their maritime zones without talking with China or Taiwan for those areas where China and Taiwan, because of the award, have no rights. This, I think, would be in principle possible, but it's impaired by the dispute over Sabah between Malaysia and the Philippines, and it's also impaired by the fear that the countries would have of adverse negative Chinese reaction to just going on. So therefore I find it quite unlikely to happen. So on this score also, the award does not really bring us much forward. So I've saved the last 2 points where my idea is that there are 2 points where possibly there could be a long-term possible implication of the award. And the first is the impact that it could have on legal thinking in China. I think we can exclude that China will accept the award at any stage, and they will continue to consider it null and void. But China may find it desirable to refute parts of the award based on solid legal argumentation. So if we should see that Chinese legal experts, in cooperation with legal experts from Taiwan, start working to undermine those parts of the award that are the most questionable. And that's not the historical rights part, it's not the U-shaped line part, but it's the part about Taiping Island, or Ituaba. If China should start building an argument there on the basis of the law of the sea and looking at precedents set by state practices elsewhere in the world, looking at this principle where it's my impression that the Arbitral Tribunal finds it that it has no importance at all if an island is big or small, that the size doesn't matter. There are several points where this part of the award, which is a key one because it's the one that says that much of the area belongs necessarily to the Philippines continental shelf and EEZ, because none of the Spratlys can have a right to more than 12 nautical mile territorial sea. If that kind of argumentation against the tribunal starts developing in a constructive way in China and Taiwan, and China in contact with the other countries starts moving towards persuading them that Woody Island in the Paracels and Ituaba, Taiping Dao in the Spratlys have a right to more than 12 nautical mile territorial sea, then this could in a way invalidate the tribunal in a fashion that starts getting China to act more in consonance with the international law. So this is in a way, it's just a hope. My fear and anticipation is that the award will just lie there and even undermine the standing of the United Nations Convention on the Law of the Sea because it is not being applied. And this is more a worry for this arbitral tribunal's award than for former arbitral tribunals which have decided on matters of less consequence and where even the disregard for the arbitral tribunal on the Nicaragua case and on the Greenpeace case, this was actually in practice resolved in some way that did not actually comply, but in some way it was resolved later. But this arbitral tribunal here is of such magnitude in its consequence that it's highly, highly unlikely that it will ever be applied by China. But then remains, I must as a peace researcher end on an optimistic note, and that's where I want to join all those who have suggested, like Professor Song also did, like that's one of the writers recently called following the fish. It's very difficult, I think, to move on the question of oil exploration, but fish is more urgent. The fisheries need protection, and you need protection of the environment. And the award opens up this opportunity that has been mentioned by many people for doing something with the territorial sea of Scarborough Shoal, where Philippines fishermen now apparently have been allowed back. It's not enough in order to make a step forward to allow them back. What is needed is a true agreement on joint management of the fisheries and environmental protection. So if China could see its chance now, its chance with Duterte as president in the Philippines, and with the new president of the United States who might be less pivoting than the one who has been there until now, China might follow up on the rather moderate reaction it has had in practice to the Arbitral Tribunal's award and make a step forward towards establishing a joint management regime for Scarborough Shoal with the Philippines, and perhaps even inviting Taiwan as a fisheries entity and Vietnam into it, since they are also recognized as having traditional fishing rights in that area. I would say that this is, if that should be done, it would have a reassuring effect also because it would show that China had no intention of constructing any facilities of a military kind at Scarborough Shoal, and it could set a precedent for similar arrangements for the smaller Spratly Islands later. So it would be an extremely favorable move to make, although it will be necessary to find a language that does not pronounce anything about sovereignty, and it would also be necessary to find a way of reconciling an arrangement for that area with the Philippines Constitution, which says that it's prohibited for any president to give up any part of the Philippines' sovereignty. Fisheries arrangements could also be made for the high seas. I really would end just by joining in all those who say that the most hopeful aspect of the current situation is the possibility of making a move on fisheries, and I would urge China to take up on that. Thank you.
Well, thank you very much, Professor Tønnesen, for your fascinating presentation. And you raised the question, will the award generate more conflict or generate more peace? I've always been an optimist for my whole life, so I would rather think it might generate more peace than conflict, but this is also a matter of conjecture. I agree with your assessment that China will not abandon artificial islands it has constructed in the area, but let us recall, the exclusive economic zone provides for resource-related rights of the coastal state concerned and does not grant that state general rights and jurisdiction. So the argument, if I recall correctly, has been made that the state concerned, which has proclaimed the exclusive economic zone, has a right to construct artificial islands for economic purposes. And if you take this literally, you might conclude that other states might construct such islands for other purposes, but this is a very isolated view. I just want to mention this. And also share your assessment that China may well refute certain parts of the award on legal grounds, because let us not forget, this arbitral tribunal for the first time has ventured into the interpretation of the highly controversial Article 121 on islands contained in the Law of the Sea Convention. So we don't know yet if there might be other tribunals or courts having to deal with the same issue, and will they build on the argumentation of the Sino-Philippines Tribunal, or will they arrive at a different conclusion? So, the next speaker, last not least speaker on my list is the most distinguished Professor Beckman, Head Ocean Law and Policy Program, Center for International Law, National University of Singapore, and his topic is the new status quo and prospects for maritime cooperation in the South China Sea.
Thank you very much, Judge Kirk. I'm not sure there's anything left for me to say, but I will run through my slides and perhaps provoke some more discussion. The outline of my presentation, first clarifying the areas, what has the tribunal's decision done in that respect, and defining rights and obligations, contrasting the arbitral award with China's island building, and then prospects for cooperation given the so-called new realities. In terms of clarifying claims, the area of overlapping claims has been significantly reduced by the award. The tribunal made clear rulings on the status and entitlement of features, ruled that Scarborough Shoal and 5 islands occupied by China are rocks entitled only to a 12-mile territorial sea and not entitled to an exclusive economic zone or continental shelf. It also ruled that all of the other islands in the South China Sea, whether they're occupied by Philippines, Vietnam, Malaysia, or anyone else, are also only rocks entitled to no more than a 12-mile territorial sea. In other words, there are no islands entitled to more than a 12-mile territorial sea. That's the various, and also the ruling on low tide elevations. Now, low tide elevations, as the name suggests, are above water only at low tide. They're not subject to a claim of sovereignty. They're not entitled to any maritime zones of their own. The Arbitral Tribunal ruled that 4 of the features that in the Spratlys that are occupied on which island building has taken place are low tide elevations. And remember, jurisdiction over low tide elevations outside the territorial sea lies with the state in whose economic zone they lie in. Now, the ruling on these issues is great significance in terms of the area of overlapping claims. Now, the second major part of the ruling, as far as my analysis goes, is that on historic rights in the 9-dash line. The Arbitral Tribunal ruled that Philippines can claim an EEZ from its main archipelagic baselines, the same way other surrounding states can claim from their coastline, but that China had no historic rights based on the 9-dash line to the natural resources within the EEZ of the Philippines. And by comparison, they have no historic rights anywhere else within the 9-dash line if the coastal states have economic zone rights. The tribunal, in effect, said whatever rights China may think it has historically, it gave those rights up when it became a party to the Law of the Sea Convention, because the Law of the Sea Convention, through its maritime zones, sets out exactly who can claim rights to resources. Therefore, China has no rights to the natural resources in the economic zone of other countries in the 9-dash line. So where are the areas of overlapping claims? The areas of overlapping claims are now only the 12-mile territorial sea around the features that qualify as islands or rocks. That's it. There are no overlapping EEZ claims. There are no, except adjacent between Malaysia and Philippines, or between Indonesia and Malaysia and Vietnam. But there are no overlapping EEZ claims with China. And this means that your disputed areas where you may talk about joint development, the only disputed areas now is 12 miles around the islands. So if we look at the map, basically the economic zone here belongs to the Philippines, here it belongs to Malaysia, Brunei, here it belongs to Vietnam. China's economic zone is up here, but this 9-dash line doesn't give China any rights to resources anymore, because there are no more historic rights within the 9-dash line. So where the areas to be shared would be this high seas area, this sort of kite-shaped area. This is continental shelf, extended continental shelf of Vietnam and Malaysia. This is Vietnam's. I assume that Philippines will be here, which means hydrocarbon resources, there's no overlapping areas anymore. The hydrocarbon resources belong to the coastal states. The fishing resources out to the 200 nautical mile zone will belong to the coastal states. And then there's a belt of high seas fishing where they can be shared. So we're talking only about sharing fisheries, not oil and gas. This is highly significant in terms of clarifying the legal positions. Now, secondly, on the island building. At the same time the Philippines pursued its case before the tribunal, China arguably pursued its case by changing the facts on the ground. Since 2013, there's a typo there. Converted 7 features into artificial islands, created a new status quo in terms of security and physical presence. What do we have now? One side has a piece of paper saying they have rights, the other side has physical control. But remember what the tribunal awarded with respect to the island building. I keep seeing comments in the Western press that China's not obeying the award, they're still on the islands. The tribunal didn't tell them to get off any islands. The tribunal didn't rule that the island building was illegal per se. The tribunal only ruled that they had violated their obligations to protect the marine environment, and they had aggravated an ongoing dispute. They said nothing about whether the state that occupies a disputed island or reef has a right to undertake activities on it. And therefore, as other states have done, they have a right to build facilities on islands, and there's no rule of international law. There's nothing in the law of the sea on this issue. So it had no ruling on whether China's reclamations were in principle illegal, no ruling on what limiting the types of installations and structures. They said nothing about that you can't militarize the islands. That's not governed by law of the sea. That's not governed by international law. You may want it to, but it's not governed. Now, the new realities. New reality one, the legal landscape has changed. We have a new status quo. The Southeast Asian claimants are likely to say, yes, what we've been saying all along, what Indonesia has been saying. China has no rights in our economic zone based on the 9-dash line. I can't imagine that Brunei and Malaysia won't say the same thing, or Vietnam, because now their economic rights belong only to them. And they're going to use it in the basis of discussions. Now, is Philippines using it? Yes. So my view on what's taking place since the award is you have talks taking place with two elephants in the room. No one talks about either elephant. One elephant is the arbitral award and the legal position, which the Southeast Asian countries will not probably deviate from. The other elephant is China and its power and the fact that it physically has control over potentially the submarine lanes and the maritime security in the South China Sea. So how do we reconcile these? China as a rising military power has created a new status quo in terms of power projection and military physical presence. Other claimants have to recognize this. They've sent a signal that they're very serious about their maritime claims and their physical presence. They feel islands that belong to them have been illegally occupied by others. You may disagree, but I think that's their historic position. South China Sea dispute's been internationalized as another change in the status quo. 10 years ago, we were talking about negotiations between the Southeast Asian claimants and China. Well, in the last 10 years, it has become internationalized. The United States, Japan, Australia, Korea, even India have taken an interest in the South China Sea, so it's not a matter that can simply be resolved anymore by the bordering states. What kind of cooperation is necessary? It's cooperation on many levels. It's between China and the bilateral negotiations with their neighbors. Also China with ASEAN as a group. China with the USA had better have some rules as to how you prevent incidents at sea, and hopefully some rules on how you can use economic zone and what FON operations are all about and how you minimize conflict arising from them. And cooperation on certain issues such as fisheries or protecting the marine environment must include other entities, where my friend Professor Song is from. Certain issues you have to bring Taiwan into the game because they're a major fishing entity and you can't solve the fisheries problem without their presence. Cooperation between China and the ASEAN claimants, it can reduce tensions and build trust and confidence. You can conserve and manage the natural resources, protect the marine environment, combat piracy and maritime crimes, minimize threats and incidents at sea, etc. The question now is, what can we do in terms of developing the resources? For 20 years, we've been talking about joint development in the area of overlapping EEZ claims. There aren't any overlapping EEZ claims anymore. So joint development's off the table. On the other hand, Philippines needs technology, Philippines needs resources. Philippines cannot develop a reed bank without the capital and the know-how, and they could strike a deal under an arrangement they could call joint development, but it may not be that as we traditionally think of it. So the problems can be resolved. Cooperation between ASEAN and the outside powers. Again, there's a perceived threat resulting from China's island building in the region. Sometimes people are calling for cooperation to counter that, and cooperation to ensure freedoms of the seas, because the other impact of the map I showed you of most of the area being economic zone of the neighboring countries, well, there's complete freedom of navigation and overflight, and I would argue freedom of military use is therefore everywhere outside the 12-mile sea around the disputed islands. So one could argue whether they're a party or not. A major winner of this award was Mike McDivitt in the United States and Donald Trump. Okay, negotiations with China. Last slide I'll take. To begin negotiations on cooperative measures in light of the new status quo. Take the new realities into account, but neither side should talk about them. Focus on matters of where your common interests. You all have a common interest protecting the marine environment and sustainably managed fisheries, for example. But you must agree from the outset that any negotiations are without prejudice to the underlying sovereignty disputes and without prejudice to the maritime disputes. Don't ask China to admit that they're going to follow the Arbitration Tribunal. Ask them to cooperate with you on protecting the environment. You probably get a lot further. Thank you very much.
Thank you very much, Professor Beckman. Well, your presentation rounded off the presentations by the previous speakers, and you have given us a more complete picture of the situation. You highlighted in particular that low tide elevations have no right to maritime zones, that there was no ruling whether the islands are legally or illegally occupied by anyone, and you also highlighted that there are no historic rights in this area, historic rights to resources in the exclusive economic zone. Well, I think as far as historic rights are concerned, one really has to distinguish between rights to living resources and non-living resources, because the prevailing view is that the rights, historic rights to living resources have been extinguished by the Law of the Sea Convention, and as far as any historic rights to non-living resources to the seabed are concerned, in my view, it would be very difficult to make an argument in favor of such historic rights in the first place, because let us not forget the continental shelf doctrine only evolved after the Second World War with the Truman Proclamation of 1945, and then it also stopped at a depth of 200 meters. So seabed rights are only a very recent development in international law. So the speakers this afternoon have all highlighted the importance of international law for international relations. At the same time, it has become very clear that international law cannot be a cure for everything. It cannot resolve all disputes because politics often prevail. Unfortunately, international lawyers might wish this were different, but it is not. And I will never forget, when I was a student at the University of Vienna, I attended a course on constitutional law, and the professor for constitutional law said, you should never forget that compared to constitutional law, international law is a primitive law. And this is still the situation a few decades later. So thank you very much for your attention to our speakers, and now the floor is open for discussion. Who would like to take the floor first? The floor is open. Yes, please.
Thank you. Nguyễn Mạnh Hùng from George Mason University, United States. I thank you very much for excellent legal argument. I have all presenter. I have two questions. Number one is that we all talk a lot about legal argument. Can we separate legal argument from the Chinese design or Chinese policy? That's number one. Number two, Professor Beckman mentioned something to the effect that the South China Sea dispute is not a problem between the negotiation between China and other countries. And claimant country is not an issue within China and ASEAN. It is also a concern of the international community. My question is, what can the international community do to express its concern or impose its concern in this case? Thank you.
Thank you. We'll collect 3 questions that I'm going to ask the panel to answer. So 2 more questions, please. Yes.
Richard Haydarian from the Philippines. Very quickly to Professor Beckman. In your slide, you mentioned that China cannot fully ignore the arbitration award because it will pay a cost. May I know your specific answer? What kind of costs will China pay if it completely ignores the arbitration award for the foreseeable future? Thank you.
Thank you. Yes, please, Admiral.
To follow up on a couple of points that were made that I am confused on, I'd like to, first, the issue of the U-shaped or 9-dash line. It's my understanding it was not totally erased. It was, as was indicated, it was just said that it was not historic right. So in terms of a cartographical annotation on charts, that 9-dash line can continue to exist as a way to assert a claim to all of the land features within the 9-dash line. That's my understanding. I just wanted to clarify that too. And this is more of the hypothetical. Mischief Reef is de facto, of the island building, it's probably the illegal one. The other ones are, and so the question is there any precedent in international law that has to do with the illegal seizure of another country's continental shelf? Because that's essentially what it is. Is this edging toward aggression, or how you would characterize it? And I'm just see if there's any precedential things that we can think about.
Thank you. So who would like to tackle the first question? Well, Professor Tennyson.
What can the international community do? It can do many things. It can provide expertise for fishery cooperation, and it can engage China and Taiwan in constructive legal argumentation, scholarship, training. So in the direction that I mentioned in my talk, I think this kind of international interaction is extremely important, and we must not just hammer on China the need to comply with the whole award, but actually welcome discussions and studies in China that question parts of the award.
Thank you. Mr. Beckman.
Yeah, I think I have a couple questions. In terms of what the international community can do, I would think the international community has an interest in activities in the oceans being governed by international laws set out by the Law of the Sea Convention, because it promotes stability and predictability in relations. I would hope that most states would have that as a high priority. In terms of costs, if China ignores, well, again, I think China, for domestic reasons and others, it's impossible for it to officially accept the decision. But what I'd ask is, what have they done to openly defy it? Have they sent their oil rigs into other countries' economic zone? Have they escorted fishing vessels into Indonesia's economic zone in defiance? Or have they quietly sat back and, like everyone else, to try to absorb the implications of what's happened? I think if they ignored it at a certain level, if they were to undertake certain activities in Vietnam's economic zone, they'd probably find themselves back before yet another tribunal with more adverse publicity and so on and so forth. So the rules of the game have changed a little bit, which inhibits what actions they can take. And it, I think, would be seriously considered when they look at their options. In terms of Mike's questions on 9-dash line, I agree with you. The tribunal said absolutely nothing. The 9-dash line's alive and well. The 9-dash line, as the map on the 47 Taiwanese map suggests, shows the location of islands in the South China Sea. I think as it was the purpose when it was drafted, it was the shorthand version for saying the islands inside this lines are the islands which China claims sovereignty over. It was never intended to govern resources or other activities. That's all post-2009. In terms of, the last question was on Mischief Reef. Mischief Reef is the most difficult problem coming out of the court's decision, because they're in effect said a low tide elevation on which China has built facilities and turned into an artificial island actually legally is under the jurisdiction and control of the Philippines because it's within their economic zone. But I wouldn't go so far as to say it was illegal taking of seabed, or it was amounts to aggression. I would disagree completely, because the tribunal went out of its way to say China was acting in good faith. We must assume they were acting in good faith. When they built on Mischief Reef, if I were representing China, they built on Mischief Reef because A, they believed it was an island, and 2, in their hearts they believed they had sovereignty over it. And therefore, but it does create the most interesting area where Philippines and China can do trade-offs. That also applies to the neighboring Second Thomas Shoal for different flip side. Thank you.
Thank you. Well, I'd like to follow up on this because you raised, Admiral, a general problem quite apart from Mischief Reef. As long as the outer limits of a continental shelf have not been delineated by coastal states, it's difficult to say where do resource-related rights to the seabed of the coastal state end, and where does the international seabed area begin? This is a basic problem. And if you look at the workload of the Commission of the limits of the continental shelf, it may take another 2 decades or more until all the submissions have been examined by the CLCS and the states can delineate the outer limit of the continental shelf on the basis of the recommendation of the Commission. Professor Anlan.
I'd like to just answer a couple of questions. First, what international community can do. As I mentioned before, an award can carry much significant role than just binding upon the party. So in this case, international community can just show the position, and the position can accumulate to form consistent practice. And in international law, consistent practice means one of the conditions to build customary international law in the future. Of course, in our immediate case, international concern, international community also create pressure toward China. It's kind of political pressure that China need to consider and consider the adjustments of their claim in the South China Sea. On the U-shaped line, yes, in principle, I agree with the answer of Professor Beckman, but you have to bear in mind that the U-shaped line is a kind of saving face for China in the way that they can still use it to claim the sovereignty issue. It doesn't matter whether the claim is legally or not, because the arbitration have no jurisdiction to talk on the strength and the weaknesses of the sovereignty claim. So its claim is just a claim, and will be subject for consideration in the future. On the midreef, I agree that at the time building construction at the midreef, it's based on perhaps good faith, but then now the conclusion of the award is coming out, so there's 3 options available for the Philippines. The first option is open negotiation with China, as Professor Beckman already mentioned. The second one, perhaps, seeking an order from another court arbitration to implement the conclusion of the first arbitration. And if there is a second scenario happen, that there is an order from a court on arbitration, recognize the need that China must restore or return the midship to China, and China failed to do so, then it's up to the Philippines to consider whether it constitutes part of their continental shelf, which is perhaps to some extent equal to their territory, and then they can consider some option under the UN Charter to take back, because in that case may consider as an aggression activity of China in ignoring the order of any arbitration or court in that sense. Thank you.
Thank you. Any more questions? We still have a few more minutes. Yes, sorry. Yes.
Well, thank you. The first question about U-shaped line and the 9-dash lines. I think it's possible to delete maybe 1, maybe 2, maybe 3, maybe all of them in the future, but subject to bilateral negotiation. So let's don't forget about the deletion of the 2 lines in 1953. And because of that deletion of the 2 lines, and we have the agreement, official agreement between China and Vietnam. So from Taiwan's perspective, 11-dash line. Is there any possibility to delete one of the lines between Taiwan and the Philippines based upon bilateral negotiation in accordance with the ruling, in accordance with the UNCLOS? It's possible. But then the second issue about international community's response, what should the international community do? You know, I think the international mass media, international community should not dance with the tunes decided by distortion. For example, we heard a lot of the report that this case is the PCA case, or some kind of confusion regarding the verdict or award made by the tribunal. There are some flaws. For example, the state concern, that comes to the third question, mischief reef. In this case, China did not agree to participate. In that situation, we're talking about mischief reef is located in the Philippines Exclusive Economic Zone continental shelf, but China disagreed. So that comes to the question, if the president of the Philippines said that, well, this award is a piece of paper with 4 corners, and China said it's a trash paper. And the Philippines, the government of the Philippines is not going to implement, not going to force the China to abide by, to implement the decision. What about the rest of international community? And the majority of international community take the position of neutral, silent, mainly because this is a very complicated issue related to national interests. So go back to the UN Charter 33, Article 33, and Article 279, the UNCLOS, negotiation between the parties concerned, China and the Philippines. I think they will do more bilateral negotiation, and other parties in the South China Sea, for example, ASEAN member state, the adoption of the COC is very important. The implementation of DOC is very important, but subject to the award, mainly because there's a need to make adjustments. Thank you.
Thank you. Question, please. Yes.
I have 2 quick observations. Both are directed to Professor Beckman. Sir, some of us lay folks have difficulty in understanding or interpreting maritime law. But as I understand it, or as I see it, when the court, the tribunal, had remarked about China's extinguishing of historic rights when it signed on to the UNCLOS, it only meant maritime entitlements and special jurisdiction rights. It did not actually mean historic fishing rights, because in the final award, the court actually did, in a sense, upheld the right of Chinese fishing boats to actually be there in the Philippines EEZ, unless they were not impeding Philippines from carrying out its own activities. So it did not debar China from carrying out any activities within, at least that is the popular interpretation. So could I have your comment on what exactly did the court mean when it said that China extinguished all its historic rights at the time that it signed onto the UNCLOS? That is one. Second, sir, it's worthwhile understanding the Chinese, the nature of the Chinese legal claim with regard to this dispute. And in a very interesting discussion in New Delhi a few weeks back, one of the Chinese scholars said that this was actually legal warfare by stealth, because the Chinese position is that this was a case of a territorial dispute that was dressed up as a case of a non-territorial dispute, or one that involved only rights and jurisdictions. And which is why they invoked Article 298 to opt out of the dispute. Now, the Philippines case was that Article 298 cannot be invoked because this has nothing to do with either military activities or territorial claims, which are the only 2 clauses on which you can actually invoke Article 298. So the Chinese say that we were done by the smartness of the legal team, of the Philippines legal team. Secondly, the Chinese also point out, and I find this very interesting, that on the mischief reef, where the Chinese had put up a representation saying that this was only to do with civilian activities, the court actually ruled against the Chinese. But on Second Thomas Shoal, where there is a Philippines ship that has been grounded, and which is very clearly military activity, the court desisted from saying anything, saying that it's not within the remit of the court to actually go into military activities. So the Chinese say that we were actually honest by bringing out that this is actually civilian activity and we paid a price for it. So has there been a misreading on our part about what the Chinese real claim was?
Thank you. We have two more questions. One, let's see. No, four more. Then the list is closed of these four. Yes, please, the lady in front.
Thank you, Professor Tuerk. I have a comments to the presentation from Professor Donaldson. He mentioned that in case if China, together with other states, criticized the judgment on a very critical points, such as the status of Itabu, then it may invalidate the award. My point of view is that from the legal perspective, the award is final and binding, and therefore there is no legal basis for any countries to invalidate the award. From the practical point of view, if a country can express its opinion or point of view on a certain part of a judgment, but in order for that opinion to become having any kind of legal effect, it requires very high criteria like the consistent practice, opinion jurists, etc. So it is not feasible for a country to react on the judgment so as to build up any kind of customary law or any kind to invalidate the award. That is my comment. And I also have a question to Professor Beckman and Professor Lanang. My question to Professor Beckman is that he mentioned that it is better for the countries in the South China Sea dispute not to tell China to follow the judgment, but to negotiate with China on the most interested questions. And my question is, do you mean that we still use the judgment as the ground for our negotiation without mentioning the judgment, since country has to base on the ground for negotiation, and what I understand is that countries in the region may use the award as the ground for negotiating, but without mentioning the award. The second part of my question to Professor Beckman is, you mentioned that there is no more question about joint development in the area of Spratly. What if China starts exploitation and exploration of gas and oil in the area of 12 nautical miles around the high tide elevation or rocks? And the questions to Professor Lanang is about, can you comment on the situation if there is an incident happens in Spratly maritime area or near the entities in the area between China and other countries, since the award is binding only upon the parties. And then the second question is, what if there is an incident happen not in the Spratly but in the Paracel? How the impact of the award can be? Thank you.
I thank the Deputy Director of the Diplomat Academy, Ms. Pham Phan Dung, for her questions, but this was a whole series of questions which are difficult to answer. So there's another lady in the back. Yes, please.
Yeah, thank you very much. I'm Minh Trang from Vietnam National University, and I have two questions, one for Professor Beckman and one for Professor Langan. The first question is about what do you think about the possibility of a litigation case in the South China Sea, not against China because it would give China a heart attack, but amongst Asian countries given the fact that now in the south, in the maritime area around the Spratly Islands, there's no overlapping EEZ and territorial sea of China in there. It just have the maritime delimitation between the Philippines and Brunei, for example, the Philippines, Vietnam, and Malaysia. What do you think about the possibilities of those countries initiate the case of maritime delimitation in the coast according to Article 287? And the second question for Professor Langan, because you say that the Arbitration Tribunal doesn't have the jurisdictions to rules on the jurisdictions on sovereignty case. But according to the final award, the tribunal say that some of the maritime features in the South China Sea, they are low tide elevations and they located within the EEZ and continental shelves of the Philippines. So it's implied that those maritime features belong to the Philippines. And it touched the case of sovereignty. So if China used that argument to reject the award, what will be your response? And thank you very much.
We have time for two more brief questions, the first row and then the second row.
Thank you very much, Chairman. I'm not an expert on international law, but I'd like to ask a question about this one. In China, some historians and legal experts always argued UNCLOS is not only the legal document in defining the dispute in the South China Sea. We still have some other documents, including the Cairo Declaration, Potsdam Proclamation, and the surrounding documents signed by the Japanese government immediately after World War II. And immediately after World War II, and also the Chinese government sent this task force to recover the islands in Nansha or Spratly Islands. And I'm not sure any panelist can give any idea on these documents, including the Cairo Declaration, Potsdam Proclamation. It's a legal chain, I think, in ratifying the legitimacy of the sovereignty in the South China Sea. Thank you.
Thank you. Last question.
Nestor Bramen with the Netherlands Embassy in Singapore. I think the lawyers, the legal experts, and the judges have done their work and still doing their work. But I think what I liked about the presentation, also, of course, I liked all the presentations, but what I liked particularly about what Professor Tunderson was doing is making the transition from the legal sphere to conflict resolution. So I would like to ask him a question. If from your expertise, you could be a bit more specific on which actors could play a role in trying to create an atmosphere that's conducive to some kind of a solution or some confidence building. Which non-state actors could play a role? Are there other non-claimant states that could play a role? Do you see any honest broker, be it a state or a non-state, that could play a role or as a mediator? And inside China itself, do you hear alternative voices inside China? And to what extent could they be supported from the outside, from this community here? Thank you.
Thank you. So last question.
Thank you very much. I'm Christian Muller from Embassy of Denmark in Hanoi, and very much in line with Ambassador Professor Tuerk. I would like to say that among the conferences on South China Sea I've attended, this is by far the most to the point and interesting and really enriching one. And therefore I would also dare to ask the panelists if about the very core issue of the sovereignty, whether international law or peace research offer any guidance or if you can offer any thoughts on how to deal with these issues of sovereignty. Are there any models like we talk about shelf or share or divide or even trade to find solutions to that? Because the region is so dynamic, and probably it will be very perhaps a little bit naive to believe that we will find an order here within decades, and there will be dynamics all the time that can escalate. So is there reason to be optimistic optimistic at all on resolving the core issues of sovereignty as well.
Thank you. So I may ask the panelists, perhaps we'll start with Professor Beckman.
Yeah, I have a bit of a hearing problem, so I'm not sure how many of these I caught. Start with the last one on sovereignty. International law governs sovereignty as a matter of customary law. You cannot have a sovereignty dispute resolved unless both parties agree to go to a tribunal. I think we've all assumed that the sovereignty disputes are so sensitive in the South China Sea that one or more of the parties are never going to agree. And therefore, we're back to the late Deng Xiaoping's statement that we should set aside the sovereignty disputes and try to cooperate or jointly develop the resources. Law of the sea has an impact on sovereignty because it tells you what you can claim sovereignty over if it's in the ocean space. You can claim sovereignty only over an island. And you have a 12-mile territorial sea in which you have sovereignty subject to passage rules. You have sovereignty over the airspace above the island and the 12-mile territorial sea. So, and you cannot claim sovereignty over a low tide elevation. But then who has sovereignty? Well, I think every Vietnamese will tell you the Paracels belongs to Vietnam, and every Chinese will tell you they belong to China. So the problem to me is not going to be resolved. They'll never reach agreement. So the question is, how do we set that aside and find our common interests in which we can cooperate? No joint development. I don't mean to be so hard on that. And no joint development as we've interpreted as legal scholars in areas of overlapping EEZ or continental shelf claims as called for in Articles 74 and 83 as provisional arrangements. That certainly does not mean that the states concerned cannot get together and agree for high seas fisheries, how they're going to be managed sustainably and who gets what share. But there's even states, if the Brunei and Malaysia are not fully exploiting the resources in their economic zone, they could certainly enter into arrangements with allowing China or Taiwan to exploit some of them. Philippines and Taiwan have reached a fisheries accord, shall we call it, that can't be a treaty, but they've worked an arrangement out. So these things are possible. They're also possible on hydrocarbon development. We have to somehow sidestep the issue of whose oil and gas it is or whatever, but I think clever lawyers can, if the political will is there can still be joint development of resources because China has the technology and capital and the Southeast Asian countries need that. So I think China, in terms of economic benefit, it might get the same benefit from a joint venture or a agreement as it might from a joint development arrangement. In terms of Chinese companies, CNOCC benefiting, it could be the same economic benefit to China. So there's no magic in calling it joint development arrangements.
Thank you, Professor Lan.
I have two questions. So the first question is, what if incident happened within 12 nautical miles of some features of the Spratly? Normally for Vietnamese people, as Professor Beckman rightly pointed out, we believe that we have sovereignty over the Spratly. However, because under international law, any competing sovereignty claim exists, then the whole features under dispute of sovereignty. So given that fact, because there are several claimants in the South China Sea claim sovereignty over the Spratly, so the Spratly is in dispute. Accordingly, the 12 nautical mile from the high tide feature of the Spratly is in dispute. So therefore, if an incident happened within the 12 nautical mile of the Spratly, then it happened within the disputed area. So it's further subject to what kind of incident happened. A kind of incident like exploiting the resources, but the renewable resources like fishing, international law allowed every country to fish at the disputed water. But a kind of activity like exploiting the hydrocarbon resources, like similar to a case called Guyana and Suriname, then it may cause an impact that cannot be restored in the future, then it's a kind of violation of international law. So similar classification of incident may happen for an area outside of 12 nautical miles, but adjacent to it. But the regime have changed because after the earthworks, then 12 nautical miles is the fixed disputed water for the Spratly, but outside 12 nautical miles, so it depends how further it is. If outside nautical mile but fall within EEZ and continental shelf of the coastal state, then as I mentioned before and many others have mentioned, that it violates the sovereign right and jurisdiction of the coastal state. If it outside EEZ and continental shelf of coastal state, so it's subject to the high sea or the area regime, so it have certain relevant provision under UNCLOS to govern it. I understand that the question raised because the earthwork only binding upon China and the Philippines. The other party only have the advantage to make use of the legal argument and to show their legal positions. So, but perhaps I understand that the legal position from the earthwork quite positive for the claimant state. So I suspect that all the other claimant states will follow the conclusion of the earthwork. And for China, if the incident happened related to China, it's obviously a violation of international law because the earthwork binding upon China. Now it moves on to the second part of the question, that what if it happened at the water surrounding the paracel? My personal view is that the paracel can be interpreted analogically to the Philippines, to the Spratly, because the natural characteristic of the two quite similar to each other. So if Vietnam, for example, can use the legal arguments from the earthwork to state that the paracels have only 12 nautical miles for the high tide features. My second question raised from Chang is that the possible confliction between sovereignty and non-sovereignty, given the earthwork have no jurisdiction on sovereignty. I think part of the answer has been given by Professor Beckman, because sovereignty claim made by the party in the South China Sea dispute hasn't made to the mainland. It made to the maritime features. But what kind of maritime features subject to sovereignty claim? It is governed by the international law of the sea, not the law on sovereignty. So first, the party need to obey international law of the sea to detect what maritime feature subject or legally claim under the law of the sea. And therefore, we have the classification between the high tide feature and the low tide features. And the earthwork clearly provide that low tide feature is not subject for sovereignty claim. And only low tide feature located within 12 nautical miles can be claimed together with the high tide, not individually. And low tide features, though located within EEZ and continental shelf, will belong to that coastal state who have the EEZ and continental shelf. And therefore, after that classification, when we're looking for the strength and the weaknesses of the sovereignty claim, it's subject to the second set of international law, which is the law on territorial acquisition. That is the matter of the answer for the third question from my colleagues come from the Denmark embassy, that the different set of law under international law of the sea only govern maritime right and obligation, but law on territorial acquisition will govern the strength and weaknesses of the legal claim of the party over sovereignty issues.
Thank you, Professor Tennyson.
Can the Arbitration Tribunal's award be invalidated? No, not in the eyes of the law. This is a binding award on the parties. Can it be ignored in practice? Yes, and it will be ignored in practice by China, and it can also be ignored in practice by other countries negotiating some kind of agreement with China in the future. So here we have to have two things in mind at the same time. What is the importance of the Cairo Declaration and other documents? They could have an impact in a question of sovereignty to the islands, but not on the questions that have been decided by this Arbitration Tribunal, which has to do with the rights of islands and matters that have to do with the sea areas. Is there any honest broker around or anyone who could play a constructive role? I think that there we must primarily look for someone who can influence the Chinese leadership, because it is China that now has a chance to decide that it is in China's good interest, strategic interest, to have secure environment with good relations with all of its neighbors in the kind of rivalry and contest that it is engaged in with the United States. The election of an uncertain new president, someone who is unpredictable in the United States, may make it even more important for China to act proactively towards having good relations with its neighbors. So if you get a Chinese leader who decides that we must have some kind of solution in the South China Sea, then it's likely that you will get it, although it will take time. Those who could influence China most, I think, is China language scholars in Taiwan and other countries that engage in legal studies in Chinese. And it's also important that Taiwan is on board because it occupies both Pratas and Ituaba. So brokers who can evolve the relationship between Taiwan and China towards cooperating in the South China Sea are those that we should be looking for. And I would not mind seeing Tsai Ing-wen in December in Ituaba with someone from mainland China at her side. The final thing is it really possible to resolve this? This is a question from our Danish colleague Møller. In the long term, it is when you have that decision, and I can easily give you a kind of recipe for what it would look like, but it takes too long to do here now. But it depends on will from the top. One of the examples that show how will on the top can produce results is the agreement that is rarely mentioned, which is real success in the Gulf of Tonkin between China and Vietnam, where the leaders of the two countries decided after normalizing their relations in 1991 to go for an agreement by the year 1999, and they told their negotiators to do it, and they managed. And since then there has been both fishery cooperation, oil exploration, joint naval exercises, and there have been a few incidents, but very little. So this is an example to be followed also for the rest of the South China Sea. Thank you.
Thank you so much, Professor Song. Well, Professor Tönnes will actually address the question to you.
Thank you. Actually, I would like to respond to the question raised by Professor Ten. Now, indeed, UNCLOS is not the only one international treaty. There are other customary international law, intertemporal law, and so on. If UNCLOS is the only one, the United States has no say in the maritime disputes in the South China Sea. And the U.S. action carried out based upon the Freedom Navigation Program is no legal base. So when we look at the South China Sea dispute, we have to examine those hard law and soft laws. Hard laws, United Nations Charter, UNCLOS, Treaty of Amity and Cooperation, and those hard laws are included in the soft law. That's the 2002 Declaration on the Conduct of the Party in the South China Sea. So I'd agree with you, Professor Ten, so not the only one. So when we're talking about historical rights, maybe not within the UNCLOS framework, there are other intertemporal law. Now come to the question when we all assume, as my friend Stein, you said that legally binding force of the arbitral award. But I would like to invite you to look at Article 296, that the condition is the tribunal has jurisdiction. But this is the key issue because China argued, no, you have no jurisdiction. If you look at the December 7th, 2014 position paper of China, arguing, no, because this is the case of putting the cart before the horse. And this case is contradiction to state consent. So those things you have to bear. So we are talking about a binding force. Then there are other things. Finally, when we try to study this issue, maybe more important is to give the parties concerned, especially the two parties to the arbitration, the Philippines and China, to follow their national interests and bilateral negotiation. And beyond those bilateral negotiations, we can go to multilateral. So I'm hoping that China and ASEAN member states can discuss more about the ongoing the adoption of the code of conduct. But all of them, China and ASEAN member states, must take note the outcome of arbitration case, because this case will have impact on the future negotiation regarding code of conduct or implementation of the DOC. Thank you.
Thank you very much. Before concluding, 1 minute for Professor Anlan and one last minute for Professor Beckman.
Okay, one quick point in response to Song and then what other countries can do. One, the decision, even though China chose a policy of non-participation and non-appearance, is legally binding on China. Let's not forget that. What can other states do to encourage promotion of rule of law under UNCLOS as well? The question that all states have to have, yes, legally binding only on the two parties, but obviously it's an authoritative interpretation of the Law of the Sea Convention, which other states should take seriously. The most controversial part of the decision was the definition of island and the decision as to how it applied to Taiping. Now, if other countries claiming economic zones around small features say that decision's binding only on China and the Philippines, not us, and they continue to claim an economic zone around small uninhabited rocks, then there will be much less respect for the decision. And anyone that tries to criticize China when they themselves are not complying with the authoritative interpretation would have little credibility. I put in that category my friends from Japan and the United States and several others who also claim economic zones around small, uninhabited, uninhabitable features.
Thank you very much for emphasizing this highly important point.
Also a quick response to Professor Song. A party to a case have a right to opposite the jurisdiction of a court arbitration, and so has China. But as long as the court and arbitration have ruled on its own jurisdiction, is final and binding. According to the competent principle, only the court and the arbitration have the right to say and conclude on its jurisdiction. And the arbitration have concluded that it has jurisdiction, so that's why the award has final and binding upon China. My second point upon the question of Professor Ching, that of course, UNCLOS is not the only source in international law, but because under international law we have treaty law, customary international law, UNCLOS also not the only treaty in the law of the sea, but in according to what have been recognized and agreed upon the widely stated practice, and according to the conclusion of the award, as to the systematically attribution, right and obligation of the state in various maritime zones, UNCLOS is the only treaty valid to divide right and obligation. The declaration that you mentioned about, for example, the Cairo Declaration, it perhaps, I agree with Professor Tonneson, perhaps it's related to sovereignty issue, but I also draw your attention that the content of all the declaration have no mention to give rights or hand back separately and parcel back to China. It's subject for only Chinese interpretation, and therefore is subject for further consideration in the future.
Thank you very much. We've had a highly interesting discussion this afternoon. I thank the panelists for the excellent presentations and the very pertinent replies to the questions. And I thank the members of the audience for asking such interesting questions. And now enjoy the coffee break.